The Factories Act 1948, Act No. 63 of 1948, Chapter IVA. Provisions relating to hazardous processes. 41C. Specific responsibility of the occupier in relation to hazardous processes. Every occupier of a factory involving any hazardous process shall a. Maintain accurate and up-to-date health records or, as the case may be, medical records of the workers in the factory who are exposed to any chemical, toxic or any other harmful substances which are manufactured, stored, handled or transported, and such records shall be accessible to the workers subject to such conditions as may be prescribed. B. Appoint persons who possess qualifications and experience in handling hazardous substances and are competent to supervise such handling within the factory and to provide at the working place all the necessary facilities for protecting the workers in the manner prescribed, provided that where any question arises as to the qualifications and experience of a person so appointed, the decision of the chief inspector shall be final. C. Provide for medical examination of every worker. A. Before such worker is assigned to a job involving the handling of or working with a hazardous substance, and B. While continuing in such job, and after he has ceased to work in such job, at intervals not exceeding 12 months, in such manner as may be prescribed. 41D. Power of central government to appoint inquiry committee. 1. The central government may, in the event of the occurrence of an extraordinary situation involving a factory engaged in a hazardous process, appoint an inquiry committee to inquire into the standards of health and safety observed in the factory with a view to finding out the causes of any failure or neglect in the adoption of any measures or standards prescribed for the health and safety of the workers employed in the factory or the general public affected or likely to be affected due to such failure or neglect, and for the prevention and recurrence of such extraordinary situations in future in such factory or elsewhere. 2. The committee appointed under subsection 1 shall consist of a chairman and 2 other members, and the terms of reference of the committee and the tenure of office of its members shall be such as may be determined by the central government according to the requirements of the situation. 3. The recommendations of the committee shall be advisory in nature. 41E. Emergency standards. 1. Where the central government is satisfied that no standards of safety have been prescribed in respect of a hazardous process or class of hazardous processes, or where the standards so prescribed are inadequate, it may direct the Director General of Factory Advice Service and Labor Institutes or any institution specialized in matters relating to standards of safety in hazardous processes, to lay down emergency standards for enforcement of suitable standards in respect of such hazardous processes. 2. The emergency standards laid down under subsection 1 shall, until they are incorporated in the rules made under this Act, be enforceable and have the same effect as if they had been incorporated in the rules made under this Act. 41F. Permissible limits of exposure of chemical and toxic substances. 1. The maximum permissible threshold limits of exposure of chemical and toxic substances in manufacturing processes, whether hazardous or otherwise, in any factory shall be of the value indicated in the second schedule. 2. The central government may, at any time, for the purpose of giving effect to any scientific proof obtained from specialized institutions or experts in the field by notification in the official gazette, make suitable changes in the said schedule. 41G. Workers' participation in safety management. 1. The occupier shall, in every factory where a hazardous process takes place, or where hazardous substances are used or handled, set up a safety committee consisting of equal number of representatives of workers and management to promote cooperation between the workers and the management in maintaining proper safety and health at work, and to review periodically the measures taken in that behalf, provided that the state government may, by order in writing and for reasons to be recorded, exempt the occupier of any factory or class of factories from setting up such committee. 2. The composition of the safety committee, the tenure of office of its members and their rights and duties shall be such as may be prescribed. 41H. Right of workers to warn about imminent danger. 1. Where the workers employed in any factory engaged in a hazardous process have reasonable apprehension that there is a likelihood of imminent danger to their lives or health due to any accident, they may bring the same to the notice of the occupier, agent, manager or any other person who is in charge of the factory or the process concerned directly or through their representatives in the safety committee, and simultaneously bring the same to the notice of the inspector. 2. It shall be the duty of such occupier, agent, manager or the person in charge of the factory or process to take immediate remedial action if he is satisfied about the existence of such imminent danger and send a report forthwith of the action taken to the nearest inspector. 3. If the occupier, agent, manager or the person in charge referred to in subsection 2 is not satisfied about the existence of any imminent danger as apprehended by the workers, he shall, nevertheless, refer the matter forthwith to the nearest inspector whose decision on the question of the existence of such imminent danger shall be final.